True crimers, welcome to Break the Case. I'm your host. I'm Jen Coffindaffer, and I thank you guys for being here 5 o'clock on a Monday. I'm really excited about this show. It's interesting. Before we started, I started looking over at the comments. I'm off and on a little bit early, just kind of reading the room on the comments and seeing what people have to say. Today's show, as most of you may know, is going to be about the Idaho case. We are going to hit on Idaho every week when there's a legal question. I am so excited to be inviting in Philip Dube. He has served as a prosecutor and pretty much a career defense attorney in Los Angeles. So a huge, huge market, huge venue. I love having him on because he walked the walk, doesn't just talk the talk. He's not, a DUI ambulance chaser type. This guy actually worked criminal law and was in the thick of it. And so that's the kind of mind that I want to have on here to give his opinions. In terms of the Idaho case, what we're going to be doing tonight is talking about Garza versus Idaho, talking about any appellate rights that Bryan Kohberger, who has pled guilty to 5 counts in the Idaho 4 murders, a burglary, plus the 4 first-degree homicides of Maddie, Ethan, Xana, and Kaylee. So we're going to be talking about that. Are there appellate rights? Let me set a quick stage for this and just say one of the first things that Judge Hippler, who oversaw this case once the venue was changed to Boise, this was one of the first things he commented on, is Garza versus Idaho. Furthermore, in his sentencing phase, he also commented on it and said he has 42 days, I believe, August 3rd, I believe, is the deadline for him to appeal, Bryan Kohberger, 163-214, to appeal. And why is he saying this? Because there are, I believe, some appellate rights caveated. But we're going to bring in Philip. I want to get this all broken down for us. It's something we need to take a look at. We're going to bring in better minds. Philip, how are you?
On a scale of 1 to 10, I'm a 9.5. How are you?
Oh, a 9.5.
That's right.
Usually, a lot of times I say I'm fair to partly cloudy, but today I'm pretty sunny. I'm pretty sunny today.
Yep, fair to middling, 9.5. How you doing?
Good. No, good. I've really been excited to talk about this particular subject because after reading Garza versus Idaho, after hearing Judge Hippler, people like me are wondering, geez, did Bryan Kohberger set this up from the beginning with this plea, knowing he was going to try to take this out? Can you break down, first of all, Philip, for us, the Garza versus Idaho case? Just give us the background of the case, not as it relates to this, but just the case.
Sure. First of all, the current landscape of the law, and this is as of 2019, the U.S. Supreme Court held in a case called Garza versus Idaho, and his name was Gilberto Garza Jr. And what happened was he took a deal. He was charged with multiple drug charges in Idaho federally, looking at life. His court-appointed defense attorney got him the deal of a lifetime. Because the penalties were so life-altering, he basically felt compelled to take the deal. He got him 10 years, and that pales in comparison to life in prison. The only caveat was he had to agree as part of the plea agreement to waive all appeals, period. And he said, okay, and he jumps on the bandwagon. Court takes the plea. It's knowingly done, intelligently done, voluntarily done. And like all good clients, a few days later, he calls his lawyer and says, the more I think about it, I want to appeal. And of course, his attorney was like, no, you don't. You don't understand what you're opening yourself up to. If you do that, we could be back to Jump Street on all your charges, and you're looking at life all over again. So no, I'm not going to do that. And what did counsel do? Counsel let the filing period lapse. And again, it's that 42-day window. At least that's the rule under today's law. He let it lapse. So Garza wouldn't let it go. He flexed, he doubled down, and I don't know if he got a hold of some appellate indigent panel to represent him on this appellate matter, or if he initiated it on his own, but somehow a notice of appeal got filed and the Idaho courts shot it down. First of all, they shot it down because they said he pled and he waived all his rights. But what did he do? He took it a step further. He appealed it on a writ of habeas corpus into federal court. And in the lower court, he lost. And then lo and behold, the U.S. Supreme Court granted review and decided to hear the appeal. And an issue was, if a defendant pleads out and waives all his appellate rights, is that absolute? Or do you still reserve the right to appeal? And what the court said is that failing to file a mere notice of appeal is a ministerial act. It is not a discretionary act, meaning if your client tells you, I want to appeal, even if it has no merit, lacks any sort of truth, validity, merit whatsoever, even if you think it would be frivolous, you are obligated under this case precedent now to file a mere notice of appeal. And all it is, it's just notice to the parties and to the Court of Appeals that you wish to appeal. And at that point, the court will appoint an appellate attorney on behalf of the appellant. And they can then brief whatever issues they feel were overlooked, disregarded, or otherwise just completely ignored at the plea stage. And what the U.S. Supreme Court said, it said, look, a defense attorney is presumptively ineffective under the 6th and 14th Amendments to the United States Constitution. And our Constitution guarantees every criminal defendant the right to effective assistance of counsel. And on a personal level, the last thing any defense attorney wants on his or her record is an allegation or a finding that you were ineffective. First of all, it looks bad. It's bad optics. They're published oftentimes, and you can be reported to the bar. And you have to answer to disciplinary charges to the state bar as to why you prejudiced your own client. In this particular case, the court found that waiving your right to an appeal is really sort of outside the scope of a plea agreement itself, because there's no way for a defendant to know really everything that he would be giving up constitutionally. So, for example, in the Bryan Kohberger case, remember, he did a motion to suppress. Ann Taylor had argued that the investigative genetic genealogy evidence was protected by the 4th and 14th Amendments, in that everybody has a constitutional right to privacy in those DNA databanks. Well, she lost in the trial court. But because Kohberger waived his right to an appeal, he is waiving his right to have a higher court review the decision of Judge Hippler denying the motion to suppress. Additionally, what you waive too, perhaps, is a motion granting or even denying venue changes. That's all waived. Or perhaps you're waiving your right to the indictment itself, that maybe the indictment was facially defective or facially invalid. It's done. The only real issue left for a higher court when you are pleading guilty or no contest with a waiver of your appellate rights is whether or not your plea was constitutionally knowing, intelligent, and voluntary. If it was, then your appeal is dead. But let's pretend hypothetically that Bryan calls up Ann and says, Ann, I appreciate everything you've done. You're a real cool lady. I love what you did for me, but I need you to file a notice of appeal. And she says, Bryan, Bubby, Bubala, listen to me. You don't want to do that, because if you do that and you somehow prevail on appeal, you're back to Jump Street and you're facing the shooting squad. I don't think we should do that, because the best we could hope for, based on all our consultations and review of the evidence, was life without parole. Why are you messing with it? Leave it be. And what does she do? She lets the 40-day window go by. Just hypothetically, I'm not saying Anne would ever do that, but let's just pretend hypothetically she does. Well, Bryan Kohberger would be presumptively prejudiced under constitutional law. But the question is, what does it get him? It doesn't get him a new trial. It doesn't get him back to Jump Street on the charges. What it gets him is an appeal. Because remember, what he waived was an appeal. So what the court would do then is send it back, order everybody to file a notice of appeal on his behalf, get appellate counsel appointed to review the record to see if there are any appellate issues. And that's where it gets a little complicated. Let's suppose a new lawyer is on board to handle Kohberger's plea, looks at everything and finds nothing. Look, we got nothing here. The best you could hope for is life without parole, and your lawyer did a good job and got you that. Don't mess with it. So what do? You file what's called an Anders brief on his behalf to the Court of Appeals. And it comes from a case called Anders versus California, United States Supreme Court case from, I want to say it was the late 50s or the 60s. But basically what Anders says is that if you are filing upon the insistence of your client a notice of appeal, and you spot no issues, then you file what's called a no merits brief, meaning you're not calling your client frivolous, you're not calling your client dilatory or just trying to stall or, having buyer's remorse. What you're really saying is, I have reviewed the record and there are no claims that should be cognizable on appeal. And what that does is it kind of gives the winky wink and a nod to the higher court that there is nothing to be done on appeal, nothing to brief, nothing to raise, nothing to discuss. And what would happen is the appeal gets dismissed. That's it. But let's suppose there is an issue. Let's just say that there really was something that got overlooked. Well, then you know what? That gets briefed. Both sides are put on notice for what's called an OSC, an order to show cause, as to why or why not this matter should not be heard for an appeal. And if the Court of Appeals disagrees, then what happens is the appeal is just dismissed. That's it. It's over. Otherwise, in the end, all it does is get the appellant an appeal. It's only then, if they prevail on appeal and win vacature of the plea of conviction, that they're back to Jump Street on the charges and you start anew. But if the Court of Appeals finds that your plea was knowing, intelligent, involuntary, and you waived it, you're done, you stand convicted, and off you go back into your 6x9 to serve LWOP.
All right, wait a minute. I'm glad you got this all out, Philip. But for those in the crowd that are a little less learned in law than you, like me, speaking about myself, especially when it comes to appeals, yes or no, Bryan Kohberger can appeal?
Yes.
Okay. Yes or no, for that appeal to be accepted, it is going to have to show that one of his constitutional rights, such as his 6th Amendment or 14th Amendment or something else, would have to be briefed. That would have to be their position. Yes or no?
Not quite.
Because you said there's a little loophole in there where they could do it with the wink, wink, saying there's really nothing here, but they have to file something. Tell us about that.
Remember, what happened in the Garza case is counsel let the 42-day notice of appeal window lapse. So by letting it lapse, he was deprived of his ability to timely appeal. If that happens, the defendant is presumptively prejudiced and counsel was presumptively ineffective. because the appellant, the defendant, did not get to be heard on his appeal. But let's say the notice of appeal is timely filed at the request of the defendant. As long as it's timely filed, then there's no allegation to make against trial counsel. The only issue now is, what is your claim on appeal? Okay, you have filed your notice of appeal. What errors were made?
Okay.
And then it would be, go ahead. So then it would be up to Kohberger, whoever's appealing, to say, well, my lawyer didn't do this, my lawyer didn't do that. And then the court's going to look to the plea. And if during the plea colloquy, separate and apart from waiving appellate rights, if it's obvious from the face of the plea and the transcript of the plea that he knowingly, intelligently, involuntarily waived all that, including defenses, the conviction stands and the appeal is dismissed.
Okay, so Philip, no matter what, you think that Ann Taylor will file a notice of appeal so she doesn't get herself in trouble like what happened with Garza?
Only if asked to by the client. Remember, you don't file appeal just as a matter of course to invite sort of trouble later or in anticipation of trouble later. You only do it at the urging of your client. If the client just is satisfied after getting his booking number, his 6x9, and whatever halal, kosher, high-fat, high-sodium meals he's getting slid under the door, he's just happy with what he got, then that'll be the end of it. However, let's just pretend hypothetically he blows the 42-day window himself. Let's just say he never asked the defense team. Then he's going to have to explain to a higher court why he blew the 42-day window. And there are provisions in the law where courts will allow you to file a notice of appeal after the 42-day window if you never asked your lawyer to do it. But at that point, you have to assert initially at the gate what your basis of the appeal is. If you don't have a lawful basis to show that you were prejudiced just by filing late, the court's not even going to let you file late. That's the standard.
Okay. How in the world would anyone know whether Kohberger asked his attorneys or didn't ask? I mean, they could say he didn't ask and he could say he did ask. So how do you even do that litmus test?
Well, first of all, Ms. Taylor would prepare a declaration under oath stating her name, her bar number, that she was trial counsel for Bryan Kohberger, and basically swear out under oath that he never asked her to appeal and that she would have gladly done it pursuant to Garza v. Idaho. She knows her constitutional obligations, but that obligation is not triggered. In other words, it's not self-executing or done in the sense that you just do it automatically as a matter of course. You only do it when asked to do so by your client. So as an officer of the court, her declaration sort of carries this imprimatur, if you will, this sort of gravitas of credibility and believability, because she's never been in trouble before. She certainly wouldn't put her reputation on the line. And it's also traceable through phone records. They can tell if Bryan ever called her or reached out in any way from prison asking her to appeal. And if he doesn't have a copy of a letter, an email, can't point to recorded phone lines, then her declaration is going to carry the day for her, and that's going to be it. That'll be it.
Okay, so let me ask you this. Why in the world would Bryan Kohberger not want to at least take his shot and appeal? Why? Why wouldn't he?
Let's just pretend hypothetically that he files that notice of appeal on time, and the court finds that his appeal was knowing, intelligent, and voluntary. The Attorney General's office in the state of Idaho has a special appellate unit within their criminal law section that litigates all the criminal appeals. They're going to submit a copy of the transcript of the plea and any waiver forms that he signed and show the Court of Appeals that he voluntarily pled. And then what they're going to do is, they could anyway, is reinstate the charges. They could actually go back to the trial level and say he breached his plea agreement. The remedy for breach is reinstatement of the charges back to Jump Street facing the firing squad. And frankly, it's not worth it, because let me tell you, when counsel gets reappointed to defend him, they ain't putting LWOP back on the table for round 2. That ship has sailed. He missed the boat, and he's trifling now with government agencies. And if he feels that he should not get death, then he can show that to a jury during the mitigation phase of his trial. So he's got to knock off the BS and stop messing around, because now he is ahead of the game with LWOP. And on a personal level, I don't think he's going to do it. I think he knows what he's up against. He took the LWOP for a reason. He had plenty of time in the county jail to get a good whiff of being a fixture of the county jail, and knows good and well what it would be like to be in a prison setting now for the rest of his life, rather than a condemned man on death row awaiting a death warrant to be marched to the death chamber, where they open the curtain and everybody can see the squad aiming a rifle at his chest and blowing him away. I seriously doubt that he's going to do that.
Well, wow, Philip, that sounds like one of my descriptions. Usually I'm the one talking all the gore. You're the one talking the legality. All right, I see what your point is. So one of the things, obviously, they did not make him talk or give any information about the crime. None. Which, again, from a federal standpoint, never seen anything like that. When we did our plea agreements, they had to debrief with us. They would have had to tell us where the knife was. They would have had to tell us where the dirty clothes were. We would have been debriefing with him probably for 20 days plus, getting every detail from the first minute he could remember life up until the time he was put in prison. Mm-hmm. So to me, that was a dropping of the ball, but I figured that that's just what they had to do on the prosecution side to make the LWOP plea agreement work. Having said that, because he, I believe, did not want to get up and say anything, all he did was say 5 yeses, Philip. Is this a precursor to, in other words, if he got up and said something, could that have hurt him in this appeal? So did that have any bearing on this, in your opinion, on what he is or isn't going to do?
Not at all. No. You got to understand something. There is a bare legal minimum that is required to enter into a plea and for it to be accepted by the court. You are advised of all your rights. That includes your jury trial rights, your right to put on a defense, your right to cross-examine, all of that good stuff. And then you're advised of all of your waivers of those rights. In this particular case, they threw in his appellate rights, which would not stand up on appeal in light of the Garza decision from the High Court. So I think an answer, and maybe I don't understand the question completely. Are you asking me, what's to stop him?
No, this is my question. I'm sorry I wasn't clear.
That's okay.
If he would have gotten up there and said to the court, I went in there, I did this, I did that, this was the order, this is what I did with the knife, this is all of this. Then if he appealed and was successful, and as you said, got to start at Jump Street again, he would have had all that on record. In other words, he would have made a full confession now that could have been used if he was retried. So for me, I just see that as a partial reason. Maybe he did not want to say anything, because if he won an appeal, that would be over his head.
No, no, and I'll tell you why. The general rule is that if you enter into a plea and it is later withdrawn, set aside, or otherwise vacated, that plea cannot be used against you ever again. Period. It is gone. And the reason why is that it was deemed invalid. So that means everything concomitant to it is also subject to vacature, and you start anew. That's the bottom line. The problem for Bryan is that if he were to pull that, he starts anew, meaning the special allegation that there were multiple victims, that it was premeditated and deliberated, would be also reinstated, and so would the 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 allegation that the special allegation that makes him death eligible. And the last thing he wants to do is to keep fighting for his life when he had already won that fight. The prosecution is not going to allow him to try to resettle for the same charges after playing all these games that really had no legal merit. They are going to reject any plea negotiations unless he wants to plead to everything and agree to be executed. But short of that, he can either take execution or a trial. And that's it.
Okay. So he takes a trial. Look at everything that's coming out, right? I mean, I've been going over the police reports and all the information, at least that we have to date. There's 300 something documents, hundreds of documents. But to be frank, we're not learning a lot more. I mean, they had what they had.
Yeah.
They had the vehicle information. They had the digital information. He wiped all his phones so they could make no connect with the victims. We have the Amazon purchase information, and we have
DNA. You got the DNA.
Yeah, the DNA is the big one. But I tell you what bothers me, and I don't think we're going to see it. It would seem is any other DNA. I got to be honest. I thought we'd see an eyebrow hair. I mean, this was a huge fight with Kaylee, and it was a huge fight with Xana. The police reports that now we're seeing are making that clear. No sweat.
Yeah.
No DNA at all. They talk about how this interaction with the other victims, and I understand he was gloved. I understand really all that was visible was about like that.
Yes.
But nevertheless, for there to be nothing more than sort of what we had, I just, and maybe I'm giving him way too much credit that this was part of the plan. He would use this Garza appeal, which I think he well knew about. I knew about it. Hitler knew about it. People knew about it. And that this was part of the plan, that they're going to do the appeal. I don't know what it's going to be based on. I want to talk to you about a couple of thoughts I had. But could this have been the plan? Or you think no, you just think there's too much in the balance and there's no way?
There's no way he's boxed in. Now, I will say if they did not have the DNA on that sheath, I'm not sure they would have ever filed. I think, or at least not as quickly as they did. Absent that DNA, it's just really a lot of curious, suspicious, circumstantial evidence, but no smoking gun to speak of. You definitely have him in the area, but you had nothing putting him in the house. Nothing. They might have had enough to detain him, maybe try to question him, but if he lawyered up and he doesn't say anything, then I don't know. I think arguably they may have found some of the Amazon search stuff that he did for the other knife sheath. They would have had the digital footprint showing his phone in the vicinity of the house for as many times as it was. And then you have also those complaints that people thought they may have seen him sort of skulking about outside the property on other occasions, almost like he was casing the place. But actually putting a knife in his hand and committing all those swipes with the knife, that just was not there. Now, what they did have, independent of his DNA, was somebody else's blood on the banister of the staircase in the house and somebody else's blood outside. I can't remember if it was on a railing or somewhere else.
No, it's on a glove.
On a glove. I'm sorry, on a glove.
That just happened after the crime scene was cleared. That was, found by actually a YouTuber that was a former officer. That is just ridiculous to even count that, because it came so far after. In other words, it was dropped after. I believe it was right by the trash cans, probably a trash man or something. But I agree with you for the just reasonable doubt, showing 2 drops of blood, perhaps they could have gotten somewhere with that. But go ahead. Sorry. The glove thing, we can't even entertain that.
Right. And that would have been fodder for the alternative or the alternate perpetrator defense. Without his DNA there, but you have 2 other persons' DNA there, I think Hitler would have allowed it into evidence. I really do, if that's all they had.
He disallowed anything to do with a third-party perpetrator. Another reason why their back was against the wall to take a plea.
I think one of the reasons why he denied it is that, let's just pretend hypothetically that he would have allowed it. Let's just pretend he would have. How does it exonerate Bryan Kohberger? They have his DNA on a knife sheath underneath one of the victim's bodies. How does that free him in any way, shape, or form? It doesn't. All it really does at most is show maybe that somebody else was in on it with him, that maybe 2 people were in on it with him. But it doesn't at all sort of negate this idea that he was ever there or had a hand in this. Well, I think at a very minimum, he would be an aider and abetter to the homicide.
It doesn't even show that another person was involved. It could have been one of the many party goers there with a hangnail.
That's true too.
Blood. I mean, there's no idea when that blood was deposited there. They never made that match because it was a party house, everybody in and out. I've always said, to me, it's a miracle they were able to disprove all the other DNA that was likely there, which God knows how much DNA would have been in that house. So from that aspect, they were able to show it matched people that should have been there, right? And I couldn't believe they were down to just that little bit on that banister. And, we all know hands have cuts, hands have hangnails. So, but I get what you're saying as a defense attorney. That's something that could have been argued, but Hitler threw all that out. So that couldn't have even been argued.
Exactly. And it's not even an issue that he can raise on appeal. He waived it. He waived that defense. That was a valid part of his plea waiver. So as far as I'm concerned, he's got no issue, at least as to the waiver of all his rights, except what we talked about earlier, and that is whether or not the plea itself was done knowingly, intelligently, and voluntarily. No higher court is going to reverse that when they look at the transcript of the plea colloquy between Kohberger and Hitler. No way whatsoever.
Okay, so the bottom line here is, yes, he has the right to appeal. Yes, likely Ann Taylor will file that.
If asked.
If asked.
Correct.
Will file that notice. And it will die on the vine after that, you believe, because there's no substance to having an appellate issue in this case.
The only way it could rear its ugly head again is if, let's say in 6 months, he calls Ann and says, gee, Ann, what's going on with my appeal? And she says, what appeal? Oh, come on, Ann. You and I had this conversation. Knock it off. I told you to file an appeal. And she's like, whoa, Bryan, we never had that conversation. What kind of allegation are you making here? Well, it's not an allegation. I'm calling you for the status of my appeal. Did you file an appeal? And she's going to say no, because you never told me to. So what can he do? He can file his own and attach a declaration saying his lawyer didn't listen to him, and pursuant to Garza v. Idaho, I want my appeal. Well, guess what? They're going to set the matter for an OSC, and Ann Taylor is going to have to submit a declaration under oath saying she was never asked to file an appeal. She had no reason to file an appeal, and she would never do it as a matter of course on a plea. Because the whole idea of pleading out is you're settling a case, taking a great deal, and closing that file. And there's an old expression in indigent criminal defense. We say a closed file is a happy file. We don't hold on to that file on a wing and a prayer that Bryan might call someday to inquire about some phantom appeal. It just doesn't work that way. So the court is going to have to look to her credibility. And if the court finds her credible, can say, look, she didn't file a notice of appeal because you never asked for one. Nice try. Appeal dismissed. And that's how it would play out, in my opinion.
All right. So I think we have our questions answered here because it's just up to Kohberger.
Correct.
Either 163214 has asked for this or he hasn't. If he has, she's going to file a notice. You don't believe from what you've seen that there's any substance to an appeal.
Nothing.
And so because of that, in other words, because it was knowing and voluntary based on all the information we have. So basically it would be summarily dismissed down the road, and that would be the end of it. I just wanted to make it clear to everybody, this is not done yet. We thought it was done, but because of Garza, it's not exactly done, but it's pretty much teetering on the cliff and about to fall down. It's about done, in other words.
Let's pretend hypothetically, though, and I agree with you. I think there is no appellate issue here. The matter is dead. The case is closed. He's doing his time. You move on to the next one. But let's just pretend in an imperfect world that he starts talking to jailhouse attorneys while locked up. And by the way, jailhouse attorneys are just fellow inmates who think they know the law. They're just a bunch of know-it-alls who have read a couple of published opinions, have been in court a few times, and they're a little more sort of, I don't know, worldly, if you will, in the justice system than Bryan Kohberger might be, despite his credential that he was working on to become a doctorate in criminology. But let's just pretend he's saying my plea was not knowing, intelligent, and voluntary because I'm autistic. Let's go with that for a second, because that might be the one card that he could play and just say that one of the symptoms of autism and Asperger's syndrome is to say yes to everything. You know, it's like somebody tapping, oh, okay, yes, yes, yes. You just say yes to everything. Okay. And you just keep repeating the same word. Yes. Do you have any questions? Yes, yes, yeah. And everything is just yes. And it's just a symptom of your condition. So then the question becomes, though, was he, based on the face of the record, so mentally disabled that you could attribute it to his autism spectrum disorder? And I could see what the court might do to resolve that issue is appoint a couple of experts to evaluate him for the prosecution, or the defense, and maybe even a third one for the court, just to break the tie in case there is a tie, and take it from there. And if they all come back sort of uniformly saying, yeah, he's Asperger's, but not to the point where he's mentally disabled. He knew the drill. He knew exactly what he was signing on to. He just had buyer's remorse. Then that's it. The appeal is dismissed.
Okay. So a lot of people in chat are saying Idaho law does not provide for, I guess, something along the line of autism to be a reason that a plea can't be knowing. I always knew that it can't be used as a defense. I always knew that. But I don't know anything, and I don't know if we need to take a look at it and revisit if it can be used to say you can't knowingly and voluntarily make a plea. I don't know about that. I do know it can be used to mitigate at sentencing, if it was even proven that he was autistic. I have my own thoughts on that. But do you know anything about a caveat in Idaho law? Or I don't know who this person is, but this person is saying you can't use that.
Let me tell you how it would work. And it's not just Idaho, it's everywhere in the United States. If defense counsel has a doubt about his or her client's mental competency, And it could be due to a settled mental illness. It could be due to a developmental disability. Counsel declares a doubt, and the court will then halt all criminal proceedings and send the client to a state hospital for evaluation and a determination of mental competency. And they come back if and when restored to competency. But let's say during that time, somehow a plea is taken when you have a doubt about your client's competency and the judge says, no, your client's fine. I don't have a doubt about your client's competency. I see him here in open court. He's conversing with you. He's chewing gum. He's laughing. He's giggly. He's interacting with everybody. No, I'm not going to declare a doubt. Well, that's a problem. Because if counsel has a doubt that his or her own client does not understand what, if anything, they're signing on to, and the judge is just overruling it, well, that could become an issue. And I would agree with the commenter in the chat that that could be a problem. But once the client is restored to competency, that doesn't negate a plea. Absolutely not. All mental incompetency means is that you don't understand the nature of the charges, or you cannot rationally assist in your own defense with counsel. And once you meet that threshold and you're competent, the court can quickly take a plea. It's not going to be vacated based on incompetency unless defense counsel is standing there saying, you know, Your Honor, I don't think we should do this plea yet. There is something up with my client. He has what I call that pseudo bull bar effect. That means the inappropriate tittering and laughter. It's like there's internal stimuli going on within him. He's laughing inappropriately. Something is wrong. I need to get him seen. Can we please declare a doubt and send him to the state hospital until he is restored to competency? And that's when you halt the proceedings and you send him off and you wait till you get a report back from the hospital certifying that he is competent. And that's when you take the plea. That's how you do it.
Okay, so back to our bottom line, because I definitely want to leave here today understanding the bottom line. The bottom line for the last time, I think, is he has an appellate right, one, under Garza, Idaho. Two, he has got to prove or be the one that asserts that with his attorney and to make it happen. And if he asserted it and, you know, it's found for whatever reason she did it, he has another avenue to go around it there. You believe that there is no appellate, nothing to back him winning an appeal. So at the end of the day, they might go through the exercise, but it'll end up dead.
Correct. Yes, I truly believe that's what would happen. And the Court of Appeals would just dismiss the appeal. And that's the end of it with prejudice. You're done. Case is over.
And you believe he won't even go that far. He won't risk the deal he's got. You don't think that we're even going to see by the 3rd of August, because my understanding is that window includes weekends. It includes, you know, holidays. It's calendar days. It's not work days.
What would happen as a practical matter? Let's just say he blows the 42-day window. And let's just say he never even calls Ann Taylor and says, you know, I want to appeal. Let's just say he does it on his own on day 43. The clerk is going to reject the notice of appeal as untimely. That's it. It's not even going to make its way through the system. The clerk's office is just going to stamp it with the conformed date on it, reject it, and maybe put a copy in the court file and send it back to the appellant and just say it's untimely. And then it would be up to him at that point to seek appellate review of the clerk's rejection of his notice of appeal. And you'd have to take it from there. But unless and until he takes those extra steps, that appeal is dead on day 43.
Right. Okay. So I just wanted to make sure, though, my understanding is it's calendar days, which includes weekends and and holidays. It's not like 43 weekdays. That makes no sense to me. But I love that question, because there are some things that go that way, but not in this particular situation, and not in most, quite frankly.
Right. It's not 42 court days. It's 42 calendar days.
Right. Perfect.
And I believe if day 42 falls on a weekend or a holiday, they get an extra day.
Okay. I believe we're at August 3rd. So we're just going to have to keep our eyes open to see if anything happens within the, documents, if anything comes through. I guess I'm more cynical than you, because I just somehow think that this was part of the plan. Again, I'm a cynic. You're a pragmatist. You're being pragmatic, saying it would be stupid. And Ann Taylor knows that, and it won't happen. We'll see what happens, Philip. I'm just saying I wouldn't be the least bit surprised to see a shenanigan.
Well, look, even if he does, it's the cash cow for all the attorneys. This is how they all get appointed and make money. They have no control over their client filing frivolous stuff in court. But if the court reappoints everybody, then everybody is back on payroll. That's how I look at it. And unless and until the court steps in and rejects all these filings or refuses to litigate and be heard on all these appeals, then, you're back to square one and everybody is reappointed, gets to submit a timesheet and get paid. Unfortunately, that is the practical effect of it all. And that is why capital appeals are so expensive. The least of it is housing the inmate on death row and feeding them and medicating them and clothing them and bathing them. The real money comes from having to litigate the endless appeals at the trial level, the court of appeals level, and on habeas. It just never ends.
Well, I think we will know by the 3rd. I think the actual date is midnight the 2nd, if I recall correctly. So on the 3rd, we're going to know if anything was done, and or it could happen before. Philip, I cannot thank you enough for giving us your legal mind, breaking down your view of this case law, breaking down Kohberger and what he'll do from your lens. It's just invaluable to all of us, and we really appreciate it.
And one final point, if I may, I'm not sure that the 42-day clock starts ticking from the date of the plea or from the date of sentencing, because ultimately you have to appeal from a final judgment. And unless and until a final order is made in the court, I don't think the clock starts ticking, but I haven't researched Idaho law. I know in California, you cannot appeal a plea until you've been sentenced. So what was the date that they did all the victim impact and he got the life without parole sentence?
Oh, boy.
It could be that the following day is the start of the 42-day clock.
Let's see if anybody else is Googling that right now. The exact day of sentencing. I do not recall that exact date. Yeah. Let's see. I'm surprised nobody's popped up with it.
It was just recent.
It was July 23rd.
July 23rd. That sounds right. Okay. So what's 42 days after July 23rd? So we're already in September.
Okay, so you get from the sentencing, not from the plea, which actually makes a lot of sense.
Yes, because you don't have a final judgment yet.
Nope. I'm going to look at it too. I didn't even think about that. I thought it was from the plea, but I wonder if it is from the sentence, which, like I said, makes more sense to me. Really, I'll have to look at that. So the 23rd was the sentence, so we may be counting from that. The plea was the 2nd, I believe, of July, the 1st or 2nd of July. Right. So that's kind of what I was counting from. So we might have clear until September 3rd. Yeah, right.
I can do a quick check. Let me see if I can see.
Oh, wait a minute. No. 40 days is outside of that. Let's see. The Kohberger plea deal. July 2nd. So the plea deal was the 2nd. The 23rd was the sentencing. So when does counting start for that?
Yeah, so here's the law. In Idaho, defendant has 42 days from the date the clerk stamps the final judgment or order to file a notice of appeal.
Okay, so there we have it. We have the answer. It's going to be from sentencing, not from
Date of the plea.
yeah.
And that makes sense. And you know why? If you really think about it, not to sound a little, I don't know, professorial and doctrinaire, the plea is sort of ongoing. Phase one of a plea is to obviously go through all the waivers, enter the plea, and then you get sentenced to probation, prison time, life, death, whatever it might be.
Mm-hmm.
So technically, you're still in the middle of a plea without a final judgment. And the general rule is you can only appeal from a final judgment or a final order. So I believe the 42-day window would kick in once he is sentenced and the clerk of court stamps the sentencing date on the sentencing sheet.
So it should be September 3rd, which is, I think, what we've said all along, from the 23rd of July.
Correct. Well, no, he was sentenced on the 23rd. Is that what you're saying?
Yeah.
Okay.
Which makes sense. I thought we said from the get-go he had till September 3rd, but I'm glad we just nailed that down.
Yes.
All
Yes.
the in the world. We're talking about sentencing, which was the final judgment for him.
Correct.
So that's where we stand. Sorry about all that math we had to do and recalling those dates, but that's correct. So,
and to all the commenters and the viewers, if I'm incorrect, feel free to chat me up and let me know, because Philip Dube makes mistakes. He's not always right, and I will stand corrected.
Okay? Yeah, no, I always say that the only perfect man hung on a cross centuries ago, if you're a Christian. So anyway, thanks everybody in chat. Thank you to the mods for always keeping everything great. And so much thanks to you, Philip, because you've got all those years of law school in your pocket and in your head. So we appreciate you breaking it down from that view. Thank you again.
And you are very welcome.
All right. Till next time, my friend. May justice be served.